My name is Victor Zapana, and I am one of the EICs for the Harvard Civil Rights Civil Liberties Law Review. Thank you so much for coming. We're the sponsor for today's event. I wanted to introduce the two panelists today, but before I do, I just wanted to draw your attention to the camera. This event is being video recorded and can be broadcast on the Harvard Law School YouTube page. We're going to have a Q&A afterward. We're going to have a mic. We're going to sort of pass it around so you can pick up your comments as you say them. If you do choose to participate in the Q&A, your image may be captured by the camera. So, to the panelists. The two lawyers who are speaking here today move along similar tracks, graduating from law school in the 90s and devoting themselves to labor and employment law. Shannon Liss-Riordan is a named partner at Lichten & Liss-Riordan, PC in Boston. Known by some clients as Sledgehammer Shannon, she specializes in class action lawsuits and is a tireless advocate on behalf of low-wage employees. Ms. Liss-Riordan tackles national cases, such as the Uber suit, and ones closer to home. For instance, she recently won a jury verdict on behalf of Skycaps at Logan Airport and negotiated a favorable settlement on behalf of workers at the Harvard Club of Boston. Ms. Liss-Riordan attended Harvard College and Harvard Law School, and she clerked for Judge Nancy Atlas of the Southern District of Texas. Professor Benjamin Sachs is the Kessenbaum Professor of Labor and Industry at Harvard Law School. He also is a founder of the popular legal blog onlabor.org, on which his most recent post is about Uber. Before entering academia, he served as a Skadden Fellow in Brooklyn, an industrial relations specialist at the U.S. Department of Labor, and an assistant general counsel for the Service Employees International Union, SEIU. Professor Sachs attended Oberlin College and Yale Law School, and he clerked for Judge Stephen Reinhart of the Ninth Circuit. And with that, I pass the mic to Professor Sachs.
Okay, hopefully people can hear me well enough.
And the mic will pick everything up.
Okay. So it's great to see everybody here. I think we can probably just cancel employment law tomorrow and call this 2 hours of credit. We have not a lot of time, and I told my wife this morning I could talk about Uber all day. But before we start, Shannon, I think I would be interested in hearing, and I think the students in the room would be interested in hearing, how you got from HLS to where you are today, in 3 minutes or less. What was your path? How did you make this happen?
Okay, that's a good question. I'll try to keep my answer to less than 3 minutes. I think I had a pretty good sense when I was here at Harvard of what I wanted to do and why I had decided to go to law school. I knew I wanted to do work to help working people fight on behalf of the little guy. I didn't know exactly what form that would take, but I naturally gravitated to labor and employment because that seemed like a logical place where you could have those kinds of battles and put your legal skills to work. So very briefly, I did a clerkship. I did a 2-year federal court clerkship after I graduated. And then I knew I wanted to come back to Boston and settle down. I got married, started a family, and I looked around and wanted to find the right place for me. So I sort of got to know the small firms in the area that were doing labor and employment. I was thinking about just starting by hanging out my own shingle, which in retrospect seems like a kind of crazy idea, but it is doable for the type of person who really knows what they want and you have the confidence to go out there and just try to learn stuff on your own and get advice from people who can be mentors to you. But I happened to be very fortunate. I think it's a matter of knowing what I wanted and being in the right place at the right time. I ended up falling in with a small firm here in Boston that ended up just being perfect. It was a small labor and employment firm doing plaintiff side, mostly discrimination, First Amendment work, but also representing labor unions in labor issues. So I started there right out of my clerkship, and I was doing mostly the employment work, but before long I started taking calls for what ended up being my focus, so wage and hour the wage and hour arena. I started taking calls from workers. It started with restaurant workers in particular. Even though no one was really doing those kinds of cases, I kind of took some cases on, and it just sort of blossomed from there. And now here I am, I guess about 17 years later. I'm with the same partner that I started with right out of my clerkship. He and I branched off about 6 years ago and started our own firm, Litigation and Liss-Riordan, doing the kind of work that I guess I had always dreamed of doing when I was in law school. So I guess my pitch on it is know what you want to do, or be open to opportunities that arise that that gel with what you want to do. There's a whole big debate. There always has been a big debate about following your heart, or going down the path that you think you need to go down because that's what everyone's doing and you have to pay off debts. But it can be done, and I would encourage everyone to go down the path where you follow your heart and do what you believe in. That's what I've done, and I've been very fortunate to have been able to do this for my career.
Okay. So why don't we start then with just an overview. An overview of where things stand in the Uber litigation. So there's a lot of moving pieces. There's a lot of different claims. Can you paint a picture of where things are today? And yeah.
Sure, and I could talk about Uber all day or all week or all month probably, so thank you for focusing the question. Big picture overview, I have a couple of cases against Uber right now. They're pending in federal court in the Northern District of California. One case is on behalf of Uber drivers in California, and another case is on behalf of Uber drivers in Massachusetts, which we originally filed here, but it got transferred to California due to a forum selection clause. The case for California, we actually had originally filed it as a national class action on behalf of Uber drivers across the country, which the federal judge out there originally agreed we could do, but then later reconsidered that decision, limited the scope for now at least to California, but the possibility is still out there that we could appeal that ruling. We got past summary judgment earlier this year. The court denied Uber's motion for summary judgment on the issue of employee status, saying that we would go to trial on the question about whether Uber drivers are employees or independent contractors under California law. And just more recently, the beginning of September, the court granted our motion for class certification. And we're now in the process of sorting out the ramifications of that order, who's in the class, who's not in the class. We're asking the court to reconsider certain aspects of his order because of certain limitations that he placed on the class, and we're figuring out what the next steps are going to be. And we actually have our next hearing in the case next week, so we'll know a lot more after that. But the big picture of it is that we brought the case on behalf of all Uber drivers who've driven for Uber Black or Uber X. Again, the case is for now limited to California. But a big issue that we have been litigating throughout the case has to do with an arbitration clause, which unfortunately is a huge issue that lawyers in this area are having to deal with. Huge issue from the plaintiff side. The defense side is really thrilled with what the Supreme Court has done in recent years to allow companies to use arbitration clauses to, among other things, but most significantly, try to limit class action lawsuits, because typically these clauses have a class action waiver buried in fine print. So we've been litigating fiercely the issue about whether this arbitration clause is enforceable. Uber rolled out the clause just a couple of weeks before I filed the case in 2013. I think they saw it coming. We actually had a little bit of a fight about that, about whether it was in response to anticipated litigation, and the judge indicated that he thought that it was. But basically what happened was I went into court, filed an emergency injunction motion to try to stop Uber from rolling out this arbitration clause to try to preemptively limit this case that we were filing. And the judge agreed that the arbitration clause had problems with it, and so he granted the motion I filed for corrective notice and to make Uber make some changes to the clause. In retrospect, it's kind of crazy how you never really know how things are going to unfold. But what ultimately ended up happening in our class certification decision is that the judge agreed that the original arbitration clause that I had challenged from 2013 when we first filed the case was unconscionable, unenforceable. It would make no difference to the class action. Uber drivers could still be part of the case even if they had to accept that earlier clause. But because of the changes that he made based on my motion to the clause in 2014, he limited, at least for now, the case to drivers who did not accept this newer version of the clause in 2014. That's part of what we're having a big fight about right now, because Uber is claiming that that's pretty severely limited the case because so much of their growth has been in the last year or so. So as things currently stand, any driver who has worked anytime since last June of 2014 is not currently in the case because of this arbitration clause. But the judge didn't say that the arbitration clause was enforceable. He said, well, it can't be part of the class because I'd have to do a case-by-case determination to determine for whom it's enforceable and for whom it's not. I'm not clear on what that determination would be made based on. So meanwhile, to prove the point that it is really kind of crazy to make every driver have to file a case individually, because the whole point of a class action is to make that unnecessary. We've been hearing from drivers all over the country and in California in particular, and we now have a motion pending with the court to allow us to add, if the court's not going to expand the class, to add more than 500 drivers individually by name to the case, and we would continue to add them as things move forward if the court continues to limit the class. So this is kind of crazy situation that we're in right now with the state of arbitration clauses, because companies are trying to use these to limit class actions, and I think their thinking is that if they can't, if the workers, or consumers in the consumer context can't bring cases as a part of a class, these claims will just go away. And part of what we've been trying to show, our firm has done this, and some other plaintiffs' firms around the country are trying to show, no, if you really want to do these cases one by one, we'll do the cases one by one. So we'll file hundreds or thousands of individual claims if need be. So that's the general kind of crazy status of where the case is right now. But the good news is that case is moving forward. I'm hoping the judge will set it for trial. We might be finding out even next week if he'll set it for trial, perhaps sometime next year.
So, as you and I have talked about, the case sort of has everything from an employment law perspective. The biggest, hottest, most contested issues in employment law today: who's an employee, who's an independent contractor, what do we do with class action waivers and arbitration clauses? Setting that aside, or asking a different kind of question, you've been motivated by social justice in your career always. How do you understand this as a social justice case? Why are you on the right side of it?
Well, this has been one of the big battles I've been focused on for about the past 10 years. Companies misclassifying their employees as independent contractors, which I do see as a social justice issue for a number of reasons. First of all, it deprives the workers of basic protections that we as a society have decided are important and should be part of the rules, part of the fabric of the employment relationship. Rules such as that if you labor for a company, if they suffer or permit you to work, if you qualify as an employee under whatever standard is applicable in that jurisdiction, you should be entitled at least to be paid minimum wage for your work, get paid for overtime if you work more than 40 hours a week, and have other basic protections such as unemployment if you lose your job, workers' comp if you get injured on your job, the right to form a union and collectively bargain if workers choose to do that. And by classifying workers as independent contractors, companies in a whole lot of industries have, for many years, just tried to get around those protections, which makes a lot of sense for the companies because they save massively on their labor costs, and it comes at the expense of the workers who are trying to live their lives, do their jobs, feed their families, pay their rent. It also hurts state and federal government when companies misclassify workers as independent contractors because government misses out on tax revenues and contributions to unemployment funds and workers' comp programs. And it's really taxpayers who pay for that when the workers who are doing work for these companies don't have basic protections, then they need to fall back on public assistance or I think it's a huge societal issue. We've been battling it, our firm in particular, in a number of industries over the years. Cleaning companies are particularly bad actors in this area. Trucking companies, I've had cases against call centers. We're seeing it pop up in more and more areas. The adult entertainment industry represented lots of strippers against a lot of strip clubs. So that's been a pretty prevalent practice in that arena too. So when Uber came on the scene a few years ago and was doing what they're doing now, calling themselves and something new, an on-demand company, a sharing economy company, everyone looked at it as though this was this brand new thing. And in a lot of ways, Uber and its progeny has created something new for the world in that it's tying together technology in a new way that allows consumers to get services more easily and more conveniently with a touch of the button at your fingertips. And I completely understand why this is so popular. Obviously, as a consumer, I know why people have been so excited about all these companies that can provide anything and everything that you want at a touch of a button. What I find really troubling is how these companies, really led by Uber, have been trying to sell to the world that because this is such a wonderful innovation for society, they should be allowed to just skirt all these rules that we put into place over decades to protect the workers who are providing the service. So Uber has been bragging to the world about how many thousands of jobs it's creating. But if you think about it, these aren't really jobs. I mean, we have a certain definition for a job in our society, and that is you work for someone, and in return you get paid and you get certain protections that our laws have put in place. So, the fact that Uber is now valued at about $50 billion, I find it a little hard to believe that it can't afford to pay the additional costs that it would, cost to provide these additional protections. I know there are a lot of other companies out there that, may not be as flush as Uber, and for whom it would be, or at least they're arguing it would be more of a hardship to have to pay these costs. But my response to that is then, if you want to be an employer, you have to live up to the responsibilities that we set in place for employers. And if you can't do that, then, you shouldn't be in business. There are ways that these companies, including Uber, I think, could adjust things, to be in compliance with the laws and keep providing this great service that everyone is so excited about. The way it works now is Uber takes a percentage of the fare. Typically, it's 20% of the fare that the customer pays. Sometimes it's more. But if it cost Uber somewhat more in overhead to cover these various protections, I don't see why they couldn't just hike their share and just adjust what the revenue is, and it comes out the same on their end, or could come out close to the same on their end. Their response would be, well, drivers might not want to drive for us if we're taking a bigger percentage. This is the percentage that everyone is happy with. But I think it would actually make it more transparent to everyone what's really going on here, because a lot of people get caught up in these companies, and Uber in particular, and don't really fully know what it is they're getting into until after they get into it. For a lot of them, it's investing in a car, making various investments, thinking that they're going to have a certain income. But then they don't really realize until they start at what it costs to pay the expenses, to cover their own vehicle costs and the other costs. And then I hear from workers who get into accidents and they're on the hook themselves for their hospital bills, and they find out they're not actually covered for workers' comp. And that's a very important cost that I don't think should be placed on the worker. It should be placed on the company that is profiting from the labor of these workers.
So sorry about the awkwardness of one microphone for two people. So we have this category in the law for independent contractors. It's a category that explicitly enables people to work and not be protected by this host of labor and employment laws. Is it your view that we shouldn't have that categorization anymore, that anybody who works should have all these protections? Or is it your view that we should have the independent contractor category, but Uber drivers don't fit it? And if that's the view, why is that? And how do we tell the difference between a legitimate independent contractor and someone who's misclassified as an independent contractor? I mean, there's 27 different tests and they each have 15 different factors. Without getting into the painful details of those, what is really the essence of the difference here? And how do we know that Uber drivers are really employees and not really independent contractors?
Well, I do think there is a place in the world for independent contractors. So I understand why the law is set up as it is, so that we have employees on one side who have this whole host of protections and independent contractors who don't. I think the problem is that the independent contractor label has been fiercely misused and abused by companies that realize that it's this great loophole to get them out of having to pay for all of these various protections. But the classic independent contractor is someone who is really and truly in business for themselves. The classic view of an independent contractor is like a plumber who comes to your home, has a whole business that they advertise, decides what services they want to provide, decides what they want to charge, puts themselves out on the market to you. You can hire them. They come in, they do one job, they get paid for that one job, then they go away, and you might hire them again in the future. That is a far, far cry from what you have with companies like Uber and the other various companies that we've been suing lately, where it is a company who is harnessing the labor of a whole lot of people to do the same thing and follow its rules and its procedures and get paid based on what the company decides they should get paid. There's no negotiation there. As you said, there are a number of tests with a variety of factors. Personally, I think all of these various tests with all these various factors I think all of the differences between them are really overblown. To be honest, I think there are like 2 tests, maybe 3 tests, and I think all of the tests just sort of like run into each other. They have very similar factors, and frankly, it just depends what judge you get in front of, how the factors are going to play out, or in some cases, what jury you get in front of. Although not very many of these cases have actually gone to a jury.
But if you were designing the test or you were interpreting the test, it would be: are you really in business for yourself? And you would say that the clearest example of that is a plumber who comes to your house, and the reason we know the plumber is in business for herself is because she sets her rate. An Uber driver is not in business for herself, and that's because Uber sets the rate. Is that the essence of the difference?
Well, I mean, it's hard not to get into a discussion of the various factors, because that is a factor, and that's a very important factor. Uber drivers do not get to set their rates. They do not get to decide how much they're going to charge. They do not get to negotiate with Uber over what cut Uber is going to take.
But in other ways, we could understand the Uber driver as in business for herself. No, she buys a car, she sets up the app, she drives when she wants to, and only when she wants to. And the only difference between the Uber driver and the plumber is that Uber sets the take rate and the rate for the driving, which is significant. But if that's right, there's a lot that's turning on that difference, and I'm not sure I get it.
Well, like I said, that's one difference. It's not the only difference. The most significant difference under most of the tests, and including California, where we're litigating the case, is the right of control. The right to set the way by which the job is done, not just the result of it. So we have a lot of evidence in the case that Uber really is setting the way the drivers are to act. They have this whole system for supervising the drivers. When they get customer complaints, they get right to the driver and they give them feedback on that. And they risk termination. And that's what the California courts have said and other courts have said is actually one of the most significant indicators of control is the right to terminate at will. So Uber does, as the court has now found, Uber has in all of its various contracts with drivers that ultimate right to decide who to deactivate in its own discretion. And it really does hold this over the drivers' heads. And we have talked with hundreds of these drivers, and we know about that power that they hold. They do it, a lot of it is done through the rating system. So customers at the end of every ride can decide to rate their driver on a 1 to 5 scale. Many customers aren't really aware of how significant that is. I've heard so many people say, oh, I really liked that driver, I'm going to give him a 4. So it turns out that in most places, if your driver does not keep an average rating of 4.6, they can be deactivated. So, it's a pretty high standard, and Uber sets that standard, and we have evidence that, the managers just say, okay, we're going to get rid of all the drivers under 4.4 right now, and they use that control. So again, that is another factor. There are other factors that we can talk about. One of them also is this a work of a highly skilled, person who needed special training and skills to perform this job, which is like the classic plumber position, or is it a relatively low-skilled position that doesn't require any prior experience, which is what an Uber driver is? But if we had to go to your bigger question, if we had to sort of boil all these factors down to sort of how do you kind of explain it most simply, one way to do it is how originally the test was supposed to be set up under the Fair Labor Standards Act, which is to suffer or permit work. It's supposed to be. Courts haven't really followed it this way, but it's supposed to be one of the broadest definitions of employment that there is. Basically, when you have a company that is suffering or permitting work by a workforce, I think they're going to be employees. We have to jump through all the hoops and, prove all the various factors, or not all the factors, but we have to prove enough of the factors to whatever judge or jury we're before to get through those hoops. But I think a big difference you have with the plumber situation and with the Uber situation is you got a big company, and you know it when you see it. They've got all of these workers who are fitting into their business model, who without these workers, this company would not survive. The independent plumber out there who, has their name online or in the yellow pages, and people, is making a name for herself, and people call her up because they know her, and then they negotiate a rate with her. That's a person who's in business for themselves. An Uber driver, just because they buy their own car and set their own schedule, doesn't make them an independent contractor. I mean, that's one of the biggest fights we're having in the case. Of course, Uber is saying, well, everyone loves the flexibility. Everyone loves being able to work whenever they want, not have the boss looking over their shoulder, checking to see if they clocked in on time. And I totally agree. I think that is a big reason why a lot of people have been doing this work. But the fact that you can set your own schedule does not make you an independent contractor. Plenty of employees are getting to set their own schedule. Employers are becoming more and more flexible, just because the workforce is demanding it and employers are responding. So Uber's argument that it's been making to the press as much as to the court is that, this case is not actually good for the drivers because they like setting their own schedule. But as I've argued, and as the judge has agreed with, there's nothing about what we're challenging that we're not challenging them having this flexible schedule. We're not saying if we win the case, we want everyone to be on a 9 to 5 schedule. If we win the case and the drivers get declared employees, it would be up to Uber whether it sticks with its current system or makes a more regimented schedule. But we're saying the system as it exists right now, the drivers are employees under the test, not that they have to go to a different kind of schedule.
Right, so now I have to ask a completely non-legal question. So people love Uber. When I've talked about this in classes and seminars, everybody loves Uber. So is it your view that people should not take Uber? And people with your commitments or your view of what's going on at Uber as an employment situation, how should people respond? Take Lyft? Take taxis? What should we do?
That is a very good and difficult question. Having sued many major employers around the country, I've tackled the question about can I patronize this company or not. There was a period of years where I didn't think there was any airline I could fly if I was going to stick with that rule. I can't go into Starbucks. I can't, So I haven't set myself with a hard and fast rule that I will not go. I will not patronize the company I'm suing. Uber, I did use early on, so I completely understand the convenience. I stopped using Uber because of particular concerns that I have about the company and how it operates, both with respect to its drivers as well as to its passengers. Unfortunately, right now, I cannot suggest what a worker-friendly ideal alternative is right now, as I've represented taxi drivers, I've represented Lyft drivers too, and unfortunately, these issues are pretty endemic. So I don't think it's very realistic that as consumers we can completely vote with our feet and turn away from these companies because they've really so pervaded our society. I guess the best that I can urge is for people to be aware of these issues and the choices they're making and possibly what impact your economic choices might have. Taxi drivers are not really in much better situation than Uber drivers right now either. But I mean, one thing to think about is that taxi drivers, as it's set up now, they have to pay for their shift. Most of them in Boston and elsewhere, that's often how it's done. So when you go for a ride in a taxi, you're helping that driver make their payment for it that day. And so I can't really say that I am telling people they should be taking taxis versus taking Uber. But these are things that I think if these companies realize that consumers are aware of, and if there are ways for consumers to voice their concerns about certain issues, companies will and may respond. I mean, a big issue, another issue I haven't even talked about, which is part of our Uber litigation. It's actually talked about in the front page of the Globe's business section today. Some of you might have seen it. Is the issue about tipping. Another claim that we have in the case is that Uber has publicized its service as being this convenient cash-free service, and there's no need to tip. And at least in early versions of their marketing materials, they even said the tip is included. After I filed these lawsuits, they took out the words, the tip is included. Because it turns out there is no tip that's included. It's just a marketing gimmick to try to make people feel okay about not tipping, which then makes the ride cheaper for the consumer. So it's really a way of artificially making the service seem more economically competitive to Uber's competitors, and that's what they want you to think. So, I mean, I'm glad the article is out today in the Globe, and there have been more reports about this issue in the media, but there is no tip included. Uber has been telling, so part of the claim that we have in the case is that Uber has advertised to the public that a tip is included, but then is not passing that tip along to the drivers. So I guess one thing I would exhort you is that if you do take a ride in Uber, tip your driver. They will appreciate it.
Another story that was out, I think today, I saw it anyway today, and is invited also by some of your comments, talks about the incredible power that these star rating systems give to consumers. So I myself have been critical of this in the sense that it gives a way of translating implicit bias into discriminatory termination decisions that would otherwise be illegal if we had a formal employment model. But it does a lot of things, and it gives riders as consumers incredible power over the livelihoods of drivers, right? It sort of transfers managerial authority in a way from the firm to the consumer. And I'm wondering if you have thoughts or advice to people in the room who are going to ride Uber or do these other sharing economy kind of platforms, how to deal with that. Yeah.
Well, that's another excellent point. I mean, frankly, this is an issue that I think has sort of permeated the service industry, more generally. I mean, if you think about it, it happens in restaurants. It happens in other places where you have tipped workers or where you have some mechanism for customers to voice their dissatisfaction and have that translate into potential management action against the workers. I mean, I have heard lots of complaints from Uber drivers in particular who say, oh, that we got a bad rating because we had a racist customer in the back seat, and what was I supposed to do about it? And now I'm at risk of being deactivated. What do I do about it? I mean, it is an issue. I mean, one thing that we do know from the evidence in the case, though, is, I mean, Uber is moderating this to some degree. You know, they're acting like an employer, using their discretion about what situations to take action on and what not to. I mean, we do have evidence that they use the rating system at times just as a cutoff. You know, if you're below this amount, you're being deactivated. If you're between this rating and this rating, you're in a, well, they have a green, yellow, and a red diagram that they show to the drivers. But if you're in the yellow section, you're basically in the warning phase, where you can do, and they've also deactivated drivers, but given them a second chance so that they can take a special training class in order to get reactivated. But we've seen evidence of them using their discretion. So I don't really know how this answers the question. But whenever you have a situation where customers are potentially injecting their bias into what end up being managerial business decisions, you know, that can be problematic if those customer feedback is based on bias. It's really the duty of an employer to manage that and make sure that those biases aren't translating into employment decisions. So, you know, on the one hand, it looks like that type of bias probably is creeping into the Uber rating system. On the other hand, Uber does seem to be managing it for better or for worse. I would say probably not for better. But again, it's another thing to think about when you're using Uber or any of these other platforms where they're asking you to rate the worker at the end of the day. I mean, think about, what does it mean? What does it mean for the worker? You know, did they have a bad day? Or you know, just because you're a little upset about something that happened, do you want to give them a lower rating, which could, you know, potentially put their employment at risk? It is just something that not a lot of people are thinking about.
Yeah. So I want to open up for questions, but I have one more. So if I've got this right, a while ago you sued a pizza company called The Upper Crust, and you won. And one thing you did was you bought one of them here in Harvard Square, and you changed the name to The Just Crust. And you changed the employment practices at the pizza company to make it a more worker-friendly environment. Is there a way of imagining a better Uber? Like, say you won and you took over Uber. What would you do? Or alternatively, if you're sitting in this room and you think, what I want to do with my legal career is be a social entrepreneur, how would you build an Uber taking advantage of this really incredible technology, but in a way that was worker empowering rather than disempowering?
That's a really big question that I don't know if I can answer in 3 minutes or less. I've been thinking a lot about those kinds of issues because it's been coming up in a bunch of the different industries we've been going after. How can the company, how could it be re-envisioned so that it is more worker friendly? There's a whole spectrum of possibilities I think there really could be for Uber drivers. You know, everything from, you know, a potentially worker-owned type model where the workers are really calling the shots and making the decisions, and there's just a whole different dynamic between the decision maker, you know, how it currently is with the decision makers on top and the workers below who are just following whatever directives that the decision makers come up with, to changes to the company. Well, I mean, one change obviously could be they could make everyone employees. So that would be our ultimate goal. I would love to see that. Somewhere in between, might there at least be some changes that are made that make life better for the workers, that make them more in control of their lives and their work, and maybe make them look a little more like independent contractors, so it would be harder for someone like me to sue them. I can envision some changes that would do that. Because the law is so, you know, obviously it's not incredibly black and white. It's not so clear cut. It's hard for me to say, well, if you tweak this thing and this thing and this thing, you're on the right side of the law. But just from what I've heard from so many drivers, I think having some of these controls that we've been talking about, having, not having this rating system hanging over their head that could be used to actually deactivate them. Having more control in deciding which customers they want to pick up. So as it is right now, the drivers get rated on things, or they're tracked on everything from, their acceptance rates to their cancellation rates. But if they had more say in which jobs they wanted to do, this applies to Uber as well as all these other platforms. Right now, when the driver gets the little beep and has to take accept the ride within a certain number of seconds, they don't know where the person is going. What if they had more information so they could say, hey, I just want to do trips to the airport, and those are the only kind of trips I'm going to take, or I just want to do short trips in my neighborhood. Maybe if they had a little more information so that they could be running the kind of business they want to run, it might be a little closer to what these companies are talking about. If there were certain protections that were in place, I've been asked this question a lot, and this question kind of frustrates me, but I've been asked a lot, isn't there some middle ground between employee and independent contractor where we would have a lot of these protections that I've been talking about, but it doesn't put all of the burden on the company? Again, my question is, why do we care so much about taking some of the burden off of a $50 billion company like Uber that has done quite well, and I think it can well afford everything, but as a second place option, if there were some further protections in place so that there was some availability of things like unemployment and workers' comp for the workers, even if they don't have the whole host of employment protections, is there some basic protection in place to make sure people aren't totally taken advantage of and forced to work for less than minimum wage? Those are all the different types of tweaks that could make the system better than it is now. I don't have a very quick, pithy answer to say this is like the one thing that will make everything better. Although, of course, having them convert to employees would go a long way.
Okay, so questions from the audience. Yeah, here.
I'm gonna try to get.
Sorry, here yeah.
Wait.
My name's Laura. I'm a 1L.
Laura.
Thank you for being here. Thank you. You talked earlier about one way that companies or Uber could handle the increased cost of having these drivers be employees is to raise the, chunk of the payment that they take from the drivers. My question is whether or not you think that that's a good idea in terms of the cost. Essentially, you'd be passing some of the cost of the benefits that these employees would get from being employees onto the drivers at the cost of their take-home pay. And given that a lot of them are already making only, $10 an hour when all is said and done without tipping, whether or not that is a good thing, or we should do something like encourage Uber to pass the cost along to people who are using their services.
Well, I think that as things are now, the costs are being passed on to the driver, but as it is now, it's not very transparent. So my point is that if Uber just came out more explicitly and said, we're going to take a bigger percentage, but we're going to be covering all of these different things for you, it would just be more clear to everyone what the situation is that they're getting into. And the reason why we have minimum wage laws is to ensure that you don't go below a certain point. So the point that we're making now is that the drivers, because they have to pay for all of their costs and all of their expenses and their gas, they may very well be below minimum wage as it is now, but they're just not quite realizing it, because it's not until you get into it and see what it actually means in your pocket at the end of the day do you realize how little it is. But if Uber came out and said, we're going to cover all of your mileage, all of your gas, all of your expenses, and this is the percentage we're taking, and then drivers looked at it and realized, hey, that means we're making $6 an hour, I think they would stand up and say something, and it would be much more clear to everyone what's going on here. So that's why I've suggested that as a way that it could, they could come more into compliance with the law, and it could just be more transparent to everyone what's happening.
Yes, please.
Hi, my name is Adabel. I'm a 1L. I actually had the experience of being an Uber driver last year, so I have the perspective of the driver and the consumer, and I understand the costs and benefits to both parties. Now, you mentioned a lot of tweaks that could potentially be made to make sure that Uber is complying to what could be determined an employee status for its drivers. Who would bear the burden of determining those tweaks and then implementing them? Is there a way to do that so that the drivers have their say, the consumers have their say, a way to avoid excess litigation to make sure that Uber is actually complying by these standards that you want them to comply with?
Well, that's a good question. I mean, the way that it works when you have litigation is, we challenge the companies because what they're doing now is not right, and then. But it's not our role to tell the company how to run its business. Typically, then the company will then, if we either win or the company tries to resolve the case, they'll try to make changes so that they're not vulnerable to being sued again. I mean, so, sometimes there's some discussion about that, either between plaintiffs and defendants in the course of a lawsuit, like, well, if we made these tweaks, we can't promise never to sue them again, but if we made these tweaks, we'd be less vulnerable to challenges in the future. So we often see that kind of dialogue happening. I mean, ideally, in a perfect world, I'd like to see workplaces unionized, and then the workers could have an official voice in what changes and policies would help them. As far as from the consumer point of view, I think that's really what the company does. The company, makes decisions deciding how it wants its business to run and will satisfy its consumers. If consumers want to have a voice in those decisions, I think they need to speak out too. And a clear way to do it is speaking with their feet, or writing about it or publicizing concerns. And because Uber has just raised so many emotions with so many different groups of people, we have been reading a lot of those suggestions from all the different points of view here.
Yeah.
You can just sort of pass the mic. Sorry. Thank you.
Thank you. Hi, my name's Marlies van Brumsen. I'm a visiting researcher here. I wonder and firstly, just thank you for your presentation. It's been really fascinating. A number of labor law scholars are talking about the fact that perhaps there needs to be a third category called dependent contractors, rather than trying to stretch this notion of what constitutes an employee. And I'd just be interested in your view on that.
Well, I've been pretty down on that idea, and that is a question that I'm getting a lot, because I feel like it's a way out for companies not to have to provide all the protections that they've had to provide in the past. Now, is it a second best option for workers to at least have some of the protections in a world where we can't get them all of the protections? Well, yes, I think that would be better than the current situation we have now, where independent contractors pretty much have none of these protections. But the reason that I hesitate to advocate for moving in that direction is because I think the practical effect is it would just let a lot of companies off the hook. I think a reason why Uber and its ilk have been championing that kind of idea, I believe, is because it takes the burden off of them and puts it on the public, really. If you have a dependent contractor that has certain protections from the company, where are these other protections going to come from? They're either going to be on the backs of the workers, they're going to be on the public. So for instance, if they have certain protections, but the workers are not, still not making minimum wage, those are workers who are going to fall back on public assistance, and it's going to be taxpayers who pay. So I just feel that going down that road is sort of an out for companies that should shoulder the burden, and I just don't know why we should be rushing so fast to take that responsibility away from employers.
My name is Mushek. I'm from LLM class. I was just wondering if at this point you knew that out of this litigation, the Uber will go bankrupt and it will go out of business. Would you still go after them?
It's just hard for me to believe that Uber is going to go bankrupt because of this litigation. I think it's got the wealth, it's got the resources to make changes that would bring it in compliance with the law. It has happened in cases that I've had with much smaller companies that really, frankly, can't afford being in business. That litigation has driven them out of business. But I go back to the point that I made earlier, is that if employers cannot afford the cost of being employers, why do we want them to be employers? I think other companies can come and take their place that can figure out how to make it work. The work will still be there. The need will still be there. I I don't think the specter that a company may go out of business if it has to comply with a law is something that we should be scared of.
I can talk loud. So one argument that Uber's made is that there will be adverse implications for the drivers who do this as filling in the gaps. So they work for 5 hours a week, or they only work when they're surging, or so what would the implications be for those types of workers? Would they be shut out from going into Uber? Do you think that's what they would do? Or the drivers who work for Uber, Lyft, and Handy and don't drive? So would it kind of consolidate control within Uber over these employees and kind of limit their flexibility, which is part of Uber's counter argument to this?
Right. Well, that is one of their big arguments, that there are a lot of people who work, very few hours, and they want to be able to keep it that way. And again, there's nothing about what we're challenging that challenges that. There are plenty of part-time employees in our economy. There are plenty of on-call employees who work, just very occasionally for an employer. But when they do work, they go in, they get their pay, they get their paycheck. If we succeed in the case and Uber decides to make changes, again, that's not something that we are asking for in the case, but I feel like that's a threat that Uber has put out there. Oh, if we win the case, they're going to make all these changes and the drivers aren't going to like it. That's the kind of argument that we hear all the time in these cases. For all the years that I've been battling on behalf of cleaning workers, and the companies have said, oh, the workers really aren't going to like having all of these protections because it's going to change things for them, or the strippers or the truck drivers, or it's just a common refrain that we hear, that what you're challenging is going to take away this flexibility that we've created, and they're not going to like that. Well, we're not telling them to take away the flexibility. If the system really works, whereby they have all these drivers out there who can work as much or as little as they want, very occasionally, if that's the system that works for them, I don't see why they wouldn't keep doing that, even if we win the case. Now, if they're only doing that just as a defense against this case, and then we win the case and they drop it, well, again, that would be their decision, but it's a little hard for me to believe that they've built this whole business model on a concept just to defend themselves against the case that I would ultimately bring against them.
All right, so I see that it's 1 o'clock. Thank you so much for coming.
Okay, thank you. Thank you very much for having me.